The Sarasota County Bar Association is a proud partner in bringing you Law and Sarasota. With voluntary membership of over 1,000 lawyers and judges, the Sarasota County Bar Association serves its members and your community by advancing legal professionalism, promoting practice development, and fostering fellowship. Visit www.sarasotabar.com for more information and to use the online directory to find an attorney.
This program is brought to you by a grant from the Community Foundation of Sarasota County and the Sarasota County Bar Association. The Education Channel produces the program and broadcasts from its state-of-the-art campus on Beneva Road. They make this program possible. Welcome to Law and Sarasota. This is a program sponsored by the Sarasota County Bar Association with a goal of informing the public of legal issues that impact daily lives. Some of us could find ourselves in a situation where we need to file a lawsuit. Maybe someone's borrowed money and hadn't paid it back. Maybe a contractor failed to perform as agreed or provided shoddy services. Or a neighbor damaged your fence. Perhaps someone borrowed your expensive lawnmower and refused to return it. There's any number of situations where, after exhausting all options, you have no alternative but to file suit. The problem is, for a lot of people, hiring a lawyer is just not practical. The amount of money involved and the costs involved do not justify the effort. So what to do? There is a path to recovery, but it is not without its challenges. Our program today is about the Small Claims Court, a division of our county court. It is designed to allow certain disputes to be pursued in court without the need for a lawyer. We will discuss the types of claims that qualify for Small Claims Court, some of the advantages and disadvantages, and we will outline the progress of these cases through the court. Our guide for this tour is the Honorable Maryann Boehm, Sarasota County Judge. She has handled literally thousands of these cases, and she knows the rules, the advantages and the pitfalls, and she may be able to offer some tips on when it might make sense to file in a small claims court and when it is not. Welcome, Judge Boehm.
Thank you. Thank you. It's good to be here.
Let's start out a little bit about your background, how you got to be a judge, and your education as a lawyer.
Well, I'm from Sarasota, so this is my hometown, and graduated from Riverview High and then went to the University of Florida and then worked for a little bit and then went to law school in Texas at the South Texas College of Law in Houston, and then came back to Sarasota, and I was a state attorney for a couple years, and then I went into private practice with developers and representing homeowners associations and condominium associations all across the west coast of Florida. So it was very busy, and it was a good backdrop because you represent private businesses and all of the things that I'm doing now as a sitting judge.
Well, in my introduction, I said that you have handled literally thousands of these cases. Did I exaggerate?
It is not an exaggeration. I've been on the bench, this is my 11th year. So over the past 11 years, I have seen a little bit of everything.
So these cases come in, of course, you have no control over how many of them. You have to be highly organized to do that, I guess. Mm-hmm.
Well, hopefully they are organized, but most of the people, you can look online. The clerk's office has a great website on how to file a small claims court, and it has a little checklist, things you need to do. And so as well as the 12th Judicial Circuit, we're in the 12th Judicial Circuit. Our website has little videos that we've put together and a whole PowerPoint. We have everything put together on how to most efficiently file a small claims suit.
Well, that'll be helpful for anybody that needs any additional information. We'll refer to that later also, mm-hmm. too. And most people don't realize that judges only have one employee.
Right. I have my judicial assistant.
And who is that?
Darlene Norris, and she handles everything, all of the scheduling, everything.
So she has to do that, one person. So roughly how many cases do you think you handle in a year on just small claims? Now,
just for small claims? I mean, it comes and goes, and the pandemic, things have been a little different with the pandemic, but probably close to 600 a year. But then I do criminal as well. So
Yeah,
it's a good balance.
It's a blended docket, right? You got criminal some days, and then you got civil, and then you have county court too. Well, county court is separate from the the small claims division. So let's just talk generally about small claims court. How did it come about? What's its reason for being?
Well, small claims court really helps pro se litigants, people who are going pro se all by themselves without an attorney's help. Most of the cases in county court, you don't need an attorney. So a lot of them are about a dispute over you had flooring installed, and 2 months after you had the flooring installed, the tiles are all popping up in your house. So it gives people a mechanism, a way to get things properly done when the company won't fix it.
Okay, so in order to keep these things running smoothly, has the Supreme Court given guidance on how to do this?
Yes, we have a rule book. So we have the Florida small claims rules. So it has to have jurisdiction, and we have to have venue in Sarasota. So the amount in controversy for small claims is now $8,000 or less. So anybody who has a claim, and a lot of them are flooring cases, air conditioner companies that aren't standing by their warranty. There's a lot of different varieties of cases that can fall under the $8,000 or less.
And so that people without lawyers who are trying to do this need to understand that the small claims rules are written very simply.
They are.
It's not a bunch of legalese. They really skewed it towards that population, that demographic, to make it simple and understandable what you have to do. So you mentioned certain types of cases. I guess you have a lot of debt collectors too coming to.
We do. There's a lot of credit card cases for people who default on their credit card, and those come through pretty quickly. So when you file a small claims case, it starts with you file the case. It's called a statement of claim. And if it's based on a contract, you would attach the contract to the lawsuit, which is your statement of claim. And you'd take that to the clerk's office, you'd pay a filing fee, and then the clerk would give you a summons. And you would have to go to the sheriff's office to have that summons with the lawsuit and the contract or whatever is attached, the documentation attached, served on the defendant so they would know to come to court.
Okay. And I think that when these people get ready to file the lawsuit, what's a typical mistake that they make when they're not represented by a lawyer?
There's obviously having a lawyer assist you is very beneficial, but you know,
not attaching the contract, for example.
They don't attach the contract, or they don't have jurisdiction. They might live in Sarasota now, but the person they're suing lives in Tampa. So the case should properly be in Hillsborough County, not in Sarasota County. But most of the cases are filed in the right way. Most of the time, people get it right.
And county court also handles residential evictions. And of course, getting the person out who hasn't paid the rent is one thing, but sometimes they do damages or they owe money for back rent. Is that the sort of case that can come in front of the small claims division?
Usually the damages portion. So if somebody moves out, the lease is over, they can come back, the landlord or property owner can come back in and say, well, now there's $5,000 of damages. They took the air conditioner, ripped it out of the house, they took all the appliances or whatever, but those are often brought in county court.
You mentioned the jurisdiction is $8,000. What if it exceeds that amount? What if they plead $9,000? What happens to that case?
If it's in small claims court, then I would have a hearing, and I would ask them if they want to keep it in small claims court or if it would be bumped up to county court. So I do have jurisdiction as a county court judge for all cases $30,000 or less, but they do not follow the small claims rules. These are only simplified rules, an expedited mechanism to keep it in small claims court. So sometimes people will waive the extra just to keep it without hiring a lawyer and keep the case moving along in small claims. But I'd have to have a hearing and talk to them and say, what do you want to do?
Okay. Now, we talked about not needing a lawyer, but you can also have a lawyer, right?
Yes, some people are represented by lawyers. And sometimes when it gets up to a trial and it's hotly contested, then people come to trial with a lawyer.
How does the attorney fees figure into the jurisdictional amount?
You don't get attorney's fees. unless attorney's fees aren't even part of the jurisdictional amount at all. But unless it's a contract and it's actually written in the contract, or there's some specific way for them to get attorney's fees, then attorney's fees usually are not recoverable.
And I guess our audience needs to know that under what we call the American system, the only time you get attorney fees is by statute or a contract.
Right.
And sometimes you'll see complaints or statements of claim say that they want attorney fees, but they're not entitled to it. There's no
Right.
basis for it. So,
And on the contrary, if they're not pled, then they don't get them either.
all right. So let's say you have a case that is more than say it's 9,000 and it should be 8. You'll set a hearing and ask the plaintiff, do you want to reduce that to our jurisdictional amount? And they may be incentivized to do that because of the cost of going to county court. All right. How about jury trials?
You can have a jury trial in small claims, and it's their right. It's in the rules. You can have a jury trial. Most of the cases do not have a jury trial. Again, people would have to hire a lawyer most likely to proceed to jury trial. Without a lawyer would be very difficult. So most of the cases are just a non-jury trial or a judge-only trial.
Have you ever had one jury trial yourself in 11 years?
Not in the small claims case division. In criminal court I have, but not for small claims.
Sure.
Nope.
Okay, so how about a situation where there's a corporation or a limited liability company, a partnership? How would they go about suing?
They can have any employee or any manager of the company as long as they're written authority. So if they have written authority that they can proceed on behalf of the company, so say Budget Rent-A-Cars wants their employee, their manager from the Sarasota airport to come in and testify and handle the case, they don't have to hire a lawyer. They can give me put written permission in the court file that he's allowed to proceed.
So you'll accept a letter from the president of the corporation?
A written authorization from a principal.
And the principals have to be somebody who has some leadership or some authority within the company. Yeah.
Most of the time it's for not Budget Rent-A-Car, but most of the time it's for a small lawn care company or something on their behalf. All
right. So let's say a person wants to demand the jury trial. How much time do they have to do that?
Well, they have to demand the jury trial usually in the pleadings, but they would have to file the proper motions and move ahead, and usually a lawyer is involved at that point. And most cases in county court settle. They don't go to trial even, so.
Well, let's talk about the process of a case that moves through. You already made reference to the statement of claim. So let's start with that process. The first thing that happens, is there a form that they can use for this?
Yes, it's on the clerk's site. So there's a form, it's almost fill in the blank. So it's a statement of claim and it can't be over $8,000. Here's my dispute. Here's why I want this money and the amount. So.
Is it sworn?
It is sworn.
Okay. So they file this paper, then what's the next step?
They would have to pay the filing fee. So for most cases in county court, it's $175, but it can go up to $300 depending on the amount. So it's staggered.
Okay. So.
And then they would get the summons, and then they would have to go to the sheriff's office most of the time, and the sheriff's office would serve that. It costs $40 for the sheriff's office to serve the entire packet, the summons with their court date and the statement of claim with the contract or documents attached.
What does the summons basically do? What does it inform the defendant of?
It summons them to court, so it tells them their next court date, their pretrial conference, and it also tells them their rights and responsibilities. Here's what you need to do. So you can.
Yeah, well, I know there's been a difference with COVID versus the way you, quote, normally handle it. Let's talk about how things are today with the COVID situation. So take us from, let's assume that the defendant has now been served and something's returned to the court that says, we've tagged this guy, the sheriff says that we've tagged him, and you say it has a date for the...
Right now it says for them to appear on Zoom. So it'll say appear on Zoom. It's usually about 3 weeks out. So appear on Zoom at this date and time. Here's the Zoom password and login information, and then they would have to appear on Zoom. If they don't appear, then they'll be defaulted.
That's interesting. So what if a person doesn't have ability to access Zoom?
Then they can call, there are kiosks at the courthouse, so there's 2 or 3 different kiosks. People can actually come to the courthouse and use one of the free kiosks.
Okay.
Or most people have it on their phone, on their smartphone.
All right. So people are more technologically oriented than they have been in the past. All right. So you give them a hearing, and is that for the pretrial conference?
That's for the pretrial conference.
What happens at pretrial conference?
If both parties appear, then they get their mediation date. And right now, those are on Zoom as well. So we have volunteer mediators. We're so fortunate who have been with us through thick and thin through this pandemic. We have just evolved and developed all of these procedures. But the volunteer mediators then they'll get new Zoom information to call in on their mediation date, or Zoom in, I guess, on their mediation date.
So let's talk a little bit about mediation, because some folks may not be familiar with it. What happens in mediation?
Well, on Zoom, they have them in separate breakout rooms. So the mediator goes back and forth to each breakout room, talking to the parties, what are your issues? And they come to a resolution, usually in small claims court, that's in a payment plan, where the defendant agrees to pay a certain amount of money every month to resolve the case, or a lump sum payment just to resolve the case and settle it.
Okay, so let's say that in mediation it doesn't work. Mm-hmm. How do you go about getting a trial date?
So at mediation, the mediator prints out, it's an impasse notice, and they would send that to the judge. We immediately get that, and then my assistant starts working on dates, and she gives it to me. We research, we'll set it for usually a pretrial conference, or we could just set it for a trial date.
Can the pleadings be filed electronically?
I believe they can through the clerk's office. Mm-hmm.
Okay. So,
especially if you have an attorney, they can just hop on and e-file it.
All right, so you have the mediation fails, impasse, as you say, mm-hmm. and then you could have a pretrial conference.
Sometimes if it's a bigger case, I'll set it for another pretrial conference where it's just me on Zoom asking the litigants how much, you have to be prepared for trial, how many witnesses are you going to have, are you going to subpoena witnesses, or if it's an attorney, they'll contact my office as well and set it for a hearing, just to touch base, like a case management conference.
All right, let's talk about trials. Mm-hmm. Assume I take it 99 or more % is in front of a judge.
Yes.
And what are the rules of evidence?
The rules of evidence apply, so you can't have hearsay. So I try to tell people when I'm telling them about how to prepare for trial and they're pro se, you can't come in and you have an issue regarding a car repair and you have a notarized affidavit, it's signed and it's notarized from the car repairman. It costs $500 to repair the car, and that's the crux of the case. That's considered hearsay, even in small claims court. You actually have to subpoena the car repairman, and he has to come, sit in the witness stand, be sworn in by the clerk, and testify, and be subject to examination and cross-examination by the parties.
So when a person's deciding whether or not to file a small claims court, they have to be thinking ahead about what are the costs to get these experts in to testify to basically the damages. Mm-hmm. And so that's...
they have to prove up their case. The plaintiff has the burden of proof, so they have to prove their case by a preponderance of the evidence. So even if they're proceeding pro se, they still have to properly get, say if it's about a contract, they have to know the questions to properly get the contract in evidence and know how to do that. So I tell people, look online, you need to do your research before you come to court.
Well, I would imagine a person who's presenting a case, either defense or plaintiff, needs to be highly organized. How much time would you give them for a trial, typically?
Most of my trials are about 1 hour to 2 hours.
Really?
Mm-hmm. They're very short.
So people who are not used to being lawyers often have a hard time compressing their questions and having them proceed in a logical fashion. Is anything available to help them do that? Is there, or do you just say you got to be prepared and you got to come in here and ask the right questions?
I tell them you need to research everything. You can look up different websites. Any website of any law firm in Florida, all around the state of Florida, it's Florida law. So it may help you if there's a law firm that specializes in auto accidents and that's your issue, you can look that up and it may give you some practicalities of how to proceed.
How about the availability of discovery? How does a person that needs to have some information developed to help prove either their defense or the claim, how do they go about getting information out?
Well, if they have an attorney, then the other party can automatically do discovery. So discovery would be usually interrogatories, which are questions that would have to be answered under oath, and document production that would have to be done. But most of the time in small claims cases, people don't want to go through the expensive and tedious discovery process. Most of the cases, within 60 days of your pretrial conference, you're going to trial. So a lot of the discovery is actually done at the trial, during the trial.
Do I understand it correctly that attorneys, if there is an attorney in the case, can ask for certain types of discovery without a court order?
Unless the other person is unrepresented.
Yes, if the other person is unrepresented.
Right.
And how about an unrepresented person? Do they have to come to you and ask permission?
Usually they do. Usually at the pretrial conference, they're asking for discovery.
Okay.
But a lot of the pro se litigants don't even know about discovery or that that's an option. And they wouldn't know how to utilize it. So but a lot of times we get two attorneys representing, the plaintiff has an attorney and the defendant has an attorney, and then they do ask to do discovery and to move the case along, and they'll waive the 60-day time period just so they can have more time to investigate the case.
One of the complicating things that's a problem now with trials is that one side or the other wants to show you their cell phone images or their text or their emails, and runs into all sorts of evidentiary issues from a technical standpoint. Have you had much of that?
I do. I say I can look at it. I can consider it demonstrative aid unless they object, but there's no way to take your cell phone and give it to the clerk and put it in evidence. The clerk would take your cell phone. So they can't, it's just something that's not possible.
But they think because it's a communication between, say, the party and them, that all they got to do is just let you look at it and it's automatically in evidence. But it comes as a real surprise because that may be their whole case.
Or emails,
Yeah.
Same thing. Emails are hard to get in.
Like a defendant may have admitted, yeah, I owe you the money, but I need more time to pay. But he gets to court and says, I don't owe you anything, and you can't impeach him because you don't have the goods to do it.
Or text messages, same thing.
Photographs, on their phone. So I guess
I try to keep it simple in small claims court. So if somebody has an email or a text message and they say they really want to show me that and we're in the middle of a trial, I'll ask the other side, do you object with that text message? Is that your number? Is that, I try to... I want to hear the evidence if I possibly can, but if they object, it's not coming in.
Well, that raises an interesting question. What are the restrictions on you as a judge when you're sitting in small claims court? What are you prohibited from doing?
It's very difficult. I can't give legal advice, and I can help people with procedures and how, I really, my hands are tied. I can't help either party, and I want to fairly hear all of the evidence and make a determination. In small claims court, you mentioned it could be a neighbor's tree fell on their fence, so it's neighbor versus neighbor. It's a lot of that, and or somebody parked their car and now they have ruts in their grass from the other person's car. But you want to just fairly hear the evidence, but still the rules of evidence apply, and things have to be properly put into evidence.
So you're a neutral umpire. You can't get in there and play the game and help somebody out, even though they may have a great defense or a solid claim and they're screwing it up. That's their problem, right?
Right.
Yeah.
They should have done their research before they came to court.
Yeah, I bet you see cases too where a defendant has a pretty good defense, but doesn't know about it because he's not a lawyer or she's not a lawyer. And you're thinking, boy, if this person just went to a lawyer, they could have slam dunk defense on this one, but they haven't done that. Okay, so let's say you've had the trial. Do you rule right then?
Yes, I rule right then. People haven't, usually, there's one time I did take it under advisement, but usually people want a ruling. They want to know what's going on.
So,
And it's nice to talk to them in person and explain to them why I'm ruling this way. Well, you didn't get the contract into evidence, so I can't consider the contract, but I think you have some kind of agreement, but I'm not finding that they owe you $1,500. And I can explain to people why. And it is the people's court. Small claims court is the people's court, and people appreciate being talked to, not down to, but explained why things are happening.
okay, so do you have the forms for the judgments on your bench?
The clerk's office hands me the form.
You fill it out. Can they get their costs reimbursed?
Usually the court costs are reimbursable. So whether it's the $175 up to the $300 plus the sheriff fee. So a lot of times it's, $350 for the court costs.
And there's also interest, legal interest.
Once the judgment hits, then there's interest that starts accruing pursuant to the statutes.
And it's pretty liberal, the amount that I forget what it is now, but it's been like.
It keeps changing.
Yeah, I think at the first of the year, January, they change everything. Okay, so.
It's been changing quarterly.
Has it quarterly? Goodness.
Yep.
Okay.
It used to be that way, and then it wasn't, and now it's back to changing quarterly.
Okay, so you hand the plaintiff, he's successful, she's successful. You give him a piece of paper.
Final judgment.
And what do they do with it?
Well, I give the plaintiff, say the plaintiff wins, I give them the copy of the final judgment, and they have the judgment, and then the defendant is there as well. They get a copy of the final judgment and a fact information sheet. So they have 45 days to fill out the fact information sheet, which is basically a financial questionnaire that they have to supply back to the plaintiff who won within 45 days, or they can just pay it within 45 days and not, or sometimes people get in settlement agreements at that point and say, I'll pay you half now and half next month or whatever.
So what if they don't fill out the fact information sheet?
If they don't do it, then there's, right on the clerk's website, there's motions to compel. So they can do a motion to compel and a show cause hearing, and if the people don't have any money to pay, then they can keep doing it and they can keep filling out the fact information sheet. But if they truly don't have the means to pay it, then there's not much the court can do.
And at that point starts the collection process, I take it, which is not easy. And
there are excellent law firms in town that handle that as well for people.
So that might be the right time if they succeeded on getting a judgment of seeking an attorney's counsel. So, well, that's interesting. Is there an appeal? Can they appeal it?
They can if they have a court reporter, but most of the cases don't have a court reporter.
And these are not recorded?
No.
Okay, unless they bring their own reporter, they can't appeal it, really.
Right.
They're stuck with it. All right. Well, folks, I see our time is up. The small claims court rules are designed to facilitate the simple, speedy, and inexpensive resolution of relatively minor disputes. However, before you go to court, take the time to talk to a lawyer. You may not need one for the trial, but you probably will to convert that paper information judgment into cash. So don't sue unless you've done your homework and you're convinced the person you're suing can afford to pay. If you're being sued in small claims court, you may have legal defenses. A brief attorney conference may be all you need to protect yourself, and you may find that you have a way to defeat or reduce the claim. If you need more information, you can find it on the clerk's website. There's also information on the 12th Judicial Circuit. Thank you, folks, for watching. This is Lee Haworth signing off for Law and Sarasota.
For more than 40 years, the Community Foundation of Sarasota County has partnered with estate planning attorneys and their clients to unlock possibilities for everyone who calls our region home. Our motto, Be the One, reflects our deeply held belief that anyone can be a philanthropist and give back to our community regardless of means. Visit www.cfsarasota.org or call 941-955-3000 for more information.